Now, 1 year later, the court comes back, and what they did in the Brown case is they remanded the decisions to the 5 district courts that the 5 companion cases had been heard in. And in Brown 2, which is the next reading here, in a very short opinion, and this is the entirety of the opinion, it goes barely more than a page. What the court has to figure out is how to desegregate. The question of whether to desegregate has been answered. Now how? And this is a classic instance where the court comes up against the limitations of its own power. If you look at the very last paragraph, this is on page 168, the second column of the reading, the court says, and again unanimously, that the judgments below, except in the Delaware case, one of the companion cases, are accordingly reversed, and the cases are remanded to the district courts to take such proceedings and enter such orders and decrees consistent with this opinion as are necessary and proper to admit to public schools on a racially non-discriminatory basis with all deliberate speed the parties to these cases. That phrase, with all deliberate speed, becomes the telltale of the court's strategy to end segregation. And we have to ask ourselves, what does with all deliberate speed mean? Well, to the South, it certainly might mean something different than to Northerners or to the justices who ruled on the decision. But what it essentially meant is that the Southern states, in any place that had legal segregation, would simply drag their feet. There are no timetables put in place at this point. There are no policies. The court can't implement a decision unless it has the backing of other branches of government. So if Congress doesn't put money towards the desegregation, if the president and the executive branch does not put troops, National Guard troops, as in the case of the Little Rock High School in 1957, then court decisions are merely words on a page. And what we see from 1954 to 1964, very little happens in the way of desegregation. The southern states drag their feet. The federal government as a whole is not wholly committed to desegregation. And it's not until 1964, with a law called the Elementary and Secondary Education Act of 1964, where Lyndon Johnson, as president, decides to put federal dollars into public schools all across the country, but certainly in the South, only if they promise to desegregate. So once the purse strings, once the money flows to the southern states, then you start to see desegregation take off. Now, the interesting thing about this is that this isn't where the education cases in desegregation ended. As a matter of fact, we're still going through desegregation cases 55 plus years later after Brown. The court tried all different types of remedies. It mandated school busing. It mandated attendance zones. It mandated rezoning entire school districts so that whites and blacks were now in the same school district. The short of it is that while the Brown case was a landmark decision, the sordid history of the last almost 60 years in the education desegregation has been not a very successful one. And there are many books and articles written about this. If you want to learn more about it, get in touch. I'm sure I can give you some references there. But at least this gets the ball rolling, and it's a very important case, both the Brown 1 and the Brown 2 decisions. Okay, what I want to do is jump ahead to the affirmative action cases. The next reading, which in your packet begins on page 309, is the landmark affirmative action case called the Regents of the University of California versus Bakke, decided in 1978. Now let me say very quickly, affirmative action as a term had been around really since around the World War II period. Franklin Roosevelt did some things to try to desegregate the federal government. John F. Kennedy talked about affirmative action, but it was really Lyndon Johnson in the mid-1960s that enhanced the profile of the concept of affirmative action. And if you think about this for a second, this is why affirmative action is so controversial. Voting rights, let's take a comparison. In 1965, Lyndon Johnson signed the Voting Rights Act of 1965, which said that you cannot discriminate against people on the basis of making them pay for registering to vote or for voting, poll taxes. You can't have grandfather clauses. You can't have literacy tests. You can't put up these barriers to voting. And if you think about it, blacks who in the South who were denied the right to vote, now who got the right to vote, really didn't threaten whites in a way that was discernible. Certainly their vote might be cast in a different way than whites, but by my getting the right to vote, you certainly don't have the diminished right to vote. It's not a zero-sum game. There is just simply an enhancement of the electorate. When you're talking about affirmative action, something very different has happened. Let us assume that there are only 50 slots in a law school, or there are only 3 jobs available in some employment place. That's a zero-sum game. There are a finite number of slots or jobs, and if I am a part of an affirmative action policy, then the ability for me to get the job decreases your opportunity to get the job. It's a zero-sum game. There's only so many pieces of the pie, and once you're talking about the potential of granting someone some type of treatment based upon past discrimination, you are potentially discriminating against someone else. That is at least the argument on the side of the opponents of affirmative action, that it is reverse discrimination. And this is why affirmative action is so controversial. The Bakke decision of 1978 really, for the first time, puts that in a spotlight. You can read here on pages 309 and 310 all about the facts of the case. It's fascinating about how Alan Bakke sought to go back to medical school. The point that I want to make here, though, is that the UC Davis Medical School had an affirmative action policy that was a racial quota. They held aside 16 slots for minorities out of a class of 100. And so what the court has to decide is whether or not this affirmative action policy or any affirmative action policy based on race is constitutional. The decision is incredibly complex. I highly encourage you to read some things about the case, but I want you to also to sort of drill down in what the court is saying. What I want to do here briefly is sort of walk you through what the decision rests on. So if you look at the first part, Justice Powell, who's writing for a very divided court and the majority, he's trying to figure out whether or not this affirmative action policy meets what we know as strict scrutiny, which is sort of a judicial standard for any race-based classification. And I'll come back to that at some point. But in order to meet the concept of strict scrutiny, the UC Davis affirmative action policy said, or at least UC Davis Medical School said, that its policy did a couple of things. Well, it was holding aside the slots because there are underadvantaged minorities. It's holding aside the slots because there is something known as societal discrimination out there, and we need to rectify it by training more doctors of color. They also claim that these minority doctors would actually go back to their own communities of color, perhaps poor, maybe underadvantaged, and practice their medicine in a way that perhaps a white doctor would not. So they were providing what they call a social good by training doctors of color. And then lastly, the medical school said that having diversity in a classroom, in a medical school classroom, is of the highest importance in their affirmative action policy and in what they're trying to do in the medical school. So the court has to go through all of these rationales and all of these arguments. And the short of it is that the court throws out all of those arguments but one. It certainly says that quotas are unconstitutional, so that's the first thing that comes out of Bakke. A quota system in an affirmative action policy is unconstitutional. You cannot simply say that I want 20% of the incoming class or of the law class to be minority, or women for that matter. So maybe some of you have this misperception that affirmative action is a quota system. It is not, and the court decided that in 1970.